With the recent controversies in regards to interaction with law enforcement, we have attorney Olivier Roche, who has practiced criminal law for over 10 years as a former prosecutor and now criminal defense attorney.
Yes. Hello, everyone. We are talking about police interaction between police and civilians. Specifically, we're talking about in the context of criminal defense, to make that clear. And so in the following examples that are going to come, or discussions, we are talking about the situation in which the police officer either has you as a subject of an investigation or perhaps someone you are with.
So are there laws that govern interactions with police?
Yes, there are laws that govern those interactions. First and foremost is the Constitution of the United States. However, more specifically, and more germane to us, is the Constitution of the State of New York and the seminal case of People versus Debour. That case, People versus Debour, holds 4 levels of interactions with the police, again in the context of you being the subject of investigation. Number 1, the police must have an objective reason to interact with you. What does this mean? This means that the police officer is free, if he sees or she sees your eye on the street, to say, hello, where are you going? Or do you have any ID? It is the right of the officer to do so, and this is the least intrusive level of interaction. The second level of the bear is a founded suspicion. What is a founded suspicion? That is, in essence, based on level 1 interaction, a hunch or a feeling that the police officer may have that something is not necessarily right with this interaction or with this person. What would be an example? An example would be while the police officer asks you for ID or says, hey, where are you going? The person starts to sweat profusely, or the person starts to fidget, or the police officer notices something in his or her hand or bag that is not right or does not fit with the picture, being the environment, the time of day. The third level is reasonable suspicion. Okay? Reasonable suspicion is something that the officer could figuratively sink his or her teeth into. I have a definitive reason as to why I believe that criminal activity is afoot. That would be either I received information, I being the police officer, of a robbery, and I see the individual that I just stopped or am talking to having what appears to be the proceeds of that robbery. Or, based on my training as an officer, I see what I recognize as a firearm protruding from the waistband or the jacket of the person that I am talking to. Again, reasonable suspicion is more than a hunch. It is something concrete that the officer observes that gives him or her reason to believe that criminal activity is afoot. In this scenario, again, the officer believes that he or she may see either contraband or a weapon on the person in which the officer has stopped. Based on that, the officer does have the right for his or her safety, as well as the safety of the general community, to have a pat down or a frisk of the individual. So at this point in time, the individual is not free to leave, as they are the subject of an ongoing investigation. Now, with level 4, we rise to what is called probable cause. Probable cause means that the officer has strong or very strong reasonable evidence of the commission of a crime that has either previously occurred moments ago or perhaps an hour ago, or of a crime that is being committed in front of him. Based on the probable cause, this is a full-blown seizure of the person, and the person who is the subject of the investigation is not free to leave.
So now that we have a better understanding of the levels, in what everyday scenario would this apply?
everyday scenario in which this would apply would be an interaction with the police officer based on a traffic violation, or in the criminal context based on a DWI interaction with an officer. With respect to DWI or even a traffic stop, the first thing that happens is the police officer pulls us over, right? The police officer pulls us over and he or she will say, "Do you know why I pulled you over?" This is a very critical point in the interaction with the police officer, because what they're trying to do is to control the flow of information and, in fact, gather information from you, the suspect, at that point in time. Now, again, going back to our levels of police interaction, based on an observation in this context, which would normally be either speeding, failing to maintain your course of travel, which means that you're in and out of your lane, or blowing a stop sign, or any other moving violation, the officer has the right to pull you over. Now, the police officer just pulled you over based on an objective reason. Again, we saw the traffic violation, whichever one you want to pick. The officer pulls you over and he or she will approach your window. The first thing that we say to the police officer as they approach the window is either nothing or, "Why is it that you pulled me over, officer?" This is very important because what the officers love to do is they'll come up to you and say, "Do you know why I pulled you over?" And the reason why they're doing this is because they are trying to extract information from you. Specifically, they're trying to extract an admission of wrongdoing. Police officers are specifically trained to do so. I like to call this verbal jujitsu, if you will. They are trained to get you to incriminate yourself and to build their investigation. Because if you tell the officer, "I failed to stay in my lane," or "I was speeding," or "I did a New York roll through the stop sign," you're giving the officer validation as to level 1, the objective reason to stop you, and you're giving him an open pass to escalate to level 2 to continue his or her investigation into your actions.